This meeting is now being recorded.
Good morning, everyone. This is Whitaker from TAC, and we are hosting a Resolving Medicaid Appeals webinar working with the CAO, presented by Kyle Fisher, staff attorney from the Pennsylvania Health Law Project, and the webinar will be available tomorrow afternoon on our website. Kyle?
Thank you, Tia. Can you hear me okay?
Yes.
Perfect. So, good morning, everyone. Thanks for joining us. This is the fourth webinar this open enrollment season, and I want to thank Tia and PAC for hosting these. I hope they've been useful for you. I certainly enjoyed putting them on. We're going to shift gears a little with this webinar. The first three were related more to substantive eligibility. So we were studying the analytic framework, so Medicaid categories, income limits, options for immigrants. Today's webinar is going to be a bit more practical, so it's going to move away from what are the rules to when mistakes happen, how do we get our clients coverage? How can we work best with the County Assistance Office to speed up applications or to speed up appeals so that our clients can get coverage as quickly as possible? As with the past webinars, I certainly encourage you to chime in if something is unclear. If you want to add a comment, if you want to pose a question, please do either use the chat box on roll call here with the webinar or unmute yourself. Star 6 to unmute and just ask that question. So I think these trainings go best if they're interactive to some extent. All right. Let's get going. So the topics, I want to cover two broad topics here. One is working with the county around applications that are still pending, and the second is working with the county on appeals. And we'll go through the mechanics of how to file them as well as tips on how to best resolve. And then we'll cover some examples, go through some common denial reasons, how to address them, and I'll show you some just template appeal emails and appeal letters. Before we get into both of those topics, I want to give you a general rule that I think holds fast for pretty much everything we're talking about today, and that is develop contacts in your local office. So in some ways, working with the welfare office is the exact opposite of working with healthcare.gov, where all of their cost staff, the marketplace cost staff, are typically all located, to the best of my knowledge, down in London, Kentucky, or at remote cost center locations. These are folks that are often up the street from you, right? Each county has a county assistance office. Some counties have multiple depending on their size. And they're human beings who, if you're working in a lot of cases in that county, you're likely to encounter repeatedly, right? So it's not you're getting some anonymous face or person who you will never work with again. You want to develop contacts within your local CAO who you can turn to for assistance. And so a few sort of pointers here. Realize, like any other human being, they make mistakes, and I think they realize that as well. Typically, you can sort of start to develop your contacts by working initially with the local ombud, and Tia has a list of each county's ombudsperson, which is a medical assistance troubleshooter who can point you towards a particular worker or supervisor, or often develop resolve an issue themselves, and that's where we typically start, or where I start at the Health Law Project. It's reaching out to an ombud if I don't already have a contact within that given county. They can be responsive by phone or oftentimes email. I think they probably appreciate email and that it allows them to look a case up to figure out what's going on before they respond to your inquiry, so they're not put on the spot. Keep in mind, too, they have huge workloads, and this goes back to the issue that they make some mistakes. They don't always know the rules the way you will, right? So this whole, when we talked about I think it was our first webinar, we talked about modified adjusted gross income. That's an income and a household methodology that's relatively new to them. These are rules they haven't been working with for years upon years upon years. So they're learning it anew. There are areas they're not going to know, and it certainly helps to have enrollment assisters like yourselves point out to them, see this section of your handbook, or look back to this policy clarification on county income for the MAGI categories for the expansion population. That can be of assistance to them, right? So you can view, in some ways, you can view your role as helping them get it right, because they will make some mistakes. And keep in mind, in addition to having a huge workload, they have to process benefit applications for all sorts of benefits. So they're not only dealing with health coverage the way we are, they have to know LAHEAP rules typically, and SNAP or food stamp rules, and cash assistance. So this goes back to, in some instances, even though this is their job and they're professionals, you are going to know their rules better than they do. So all of that said, as you develop contacts, and again, you want to treat them well because you want them to be responsive when you contact them, but you also want to be credible, right? So in terms of pointing out their mistakes, make sure you're on firm footing, right? So go back to their own handbooks and find where's the rule that supports what you're arguing. And if it's not in the handbook, look to see if it's in a policy clarification or an ops memo, and certainly use us. Use the Pennsylvania Health Law Project and pulling up those rules so that when you present something to them, again, you know what you're talking about, right? But you certainly don't want to reach out to them and be wrong about something because it will color your future interactions with them as well. The top bullet point under the first rule there, they have no interest in going to fair hearings. We're going to come back to this theme repeatedly this morning. When you file an appeal, to some extent it creates more work for them. Right, and we'll get into the appeals when we get to the appeal section in a few minutes. But it sets in place a mechanism whereby a fair hearing is set up with an administrative law judge 2 to 3 months down the road. Right? They have no interest in doing that. And typically, well, depending on how your client files the appeal, it may require that they go out of their offices, travel to a different location, and defend their decision. Right? So you want to use that to your advantage, right? Certainly our clients have a legal right to file an appeal, but you also want to give the caseworker whatever information they need to authorize the benefit. So they don't have to go to that fair hearing 2 to 3 months down the road. So they don't have to file the appeal with Bureau of Hearings and Appeals, because their impulse, it's going to be their preference, is going to be to take care of that as quickly as possible so they can keep going, so they can get to the other things they have to do, the other stack of applications on their desk, if you will. And part of making their jobs easier is not only putting out the right rule, but giving them whatever information they may need just to turn the benefit on. All right, that was a long preface. Now we have that. Let's keep moving here. Applications, and this is touching on something that I know we talked about a little bit in past webinars as well. The general application framework is 30 days. So once the client has submitted the application, typically the county is supposed to process it within 30 days. If additional information is needed, sometimes that can be pushed back to 45. But they have a dashboard within the local counties. They're trying to meet that 30-day time frame for Medicaid applications. As we've talked about, you can speed that up to 5 days if the applicant has a medical emergency. So I know most of you work either embedded in a health center or alongside a health center. I think you can make it routine practice for those applicants you're working with who have chronic medical issues or have an issue that needs immediate treatment or a pharmacy. You can develop a template letter, a basic letter that one of the clinicians in your health center can sign that outlays the patient's condition and describes what it is. You might have just a blank section where they can report what could happen without treatment, and then just a stock language. Please process within 5 days per Section 303.13 of your eligibility handbook. And you see a screenshot there at the bottom of this page that is the beginning section of that handbook provision, right? So you can certainly look to the handbook. Hopefully all of you have had a chance to bookmark that, the Medical Assistance Eligibility Handbook. And these are the rules that guide the day-to-day functioning of caseworkers, their day-to-day activity. beyond asking them to speed up an application, let's say you already asked them to speed up an application, but you can see in Compass or you know otherwise the client hasn't yet got a decision. What can you do? And this is something that we do fairly routinely. Is for any application that's pending, be it under or over 30 days, you can ask, right? You can reach out to your CAO contact or the Ombud and ask, what's the status of Jane Doe's application? What's the status of my client's application? Now, you do want to be somewhat judicious in this, right? Because it's taking some time out of their day for them to pull and see what the actual status is, whether any additional information is needed. So I think typically you want to do this if you know the client's app has been pending for over 30 days, so it's due, essentially. You might want to do this if you're not sure what else the county needs, but you think some information was requested, your client doesn't have that letter they received, et cetera, to see what else is needed. Or you might do it if you know your client has some health needs, right? They need to address something immediately. So even if they didn't ask the county to expedite, even if they didn't submit that doctor's letter on the front end, when you ask, when you submit this status request, you can give them additional medical information now and say, please expedite this, please speed up this application because my client suffers from anxiety and needs to fill this prescription. Right? And you can do that with or without the medical letter. Of course, it's going to help to have something from a clinician that supports your assertion. When you do a status request, regardless of whether you do it via email or you do it by a phone call, you want to point out a couple of things. One, of course, the client's name, but also some sort of identifying information. So if you have a recipient number, put that in there. If you don't, put a date of birth. The second piece, when you point out, this goes back to being credible, you want to point out the eCompass number or the eForm number from the Compass submission if it's an application that you submitted with the client. So that will help them identify it, but it also it proves the assertion of when the person submitted the application. If you don't have that, you want to say, Ms. Doe reports filing the application by phone on November 20th or whatever the date is, right? And I think the wording there can be important because our clients don't always have the exact dates, right? And the county is going to be able to pull up, and if our client reports applying in October, but your contact sees that they didn't actually apply until after Thanksgiving, it goes back to undermining your credibility, right? And again, you want to be straightforward with the CAO, and you want them to view you as knowing what you're talking about, right? So the caseworkers sometimes make mistakes, but our clients make mistakes sometimes as well. Let's look at an example here. So here's an email example from a pending application that I submitted to Allegheny CAO about a year back. And I want to point out a few things here. You can see, and this is a contact we had, and unfortunately Mr. Galanowski has since retired from state employment, but he was responsive and generally he knew the rules and he was willing to try and help in situations like this. So I was inquiring about the status. I was working with an older adult, her daughter, who had applied through Compass last December. So you'll see she had an eForm number. We also gave a date of birth. What they hadn't reported was that the client here had a mental health disorder and uncontrolled diabetes. So since the daughter had some sort of discharge report or she had some medical documentation that she had scanned and sent to me, I included that in the email and I asked the county to speed it up. So this does a couple of things, right? Beyond just putting in motion the technical expedite, resolve it in 5 days, it gets a live body at the county assistance office to actually pull your consumer's application, right? It gets a new set of eyes on it, and typically, once they've pulled it, they're going to see, is there anything else needed? And if not, the Ombud or the supervisor is going to ask, a worker, fix this, process this case, right? Certainly if, as in a case like this, there's some medical information here showing that this client needs Medicaid as soon as possible, right? It gets your client's case pulled to the top of the pile and hopefully processed. And sometimes there's something still pending. So in this particular case, actually, they had asked for verification of the client's checking account. And typically my response to that is she's applying for coverage through the new ADO, the expansion category, and savings, assets are not they're not an eligibility component. So please process without that. But what they had seen in their back-end data match is that she was getting income, or she was getting a transfer into that account that hadn't been reported. And her daughter was actually doing a checking account to checking account transfer to help her mom pay for medications. And those transfers were substantial. I think what the county had seen was a transfer of $500, and that went to paying for insulin and other diabetes meds. So we had to address that because income coming in, routine transfers does go to your client's income. So it took a little more time to actually get this client's Medicaid turned on. But by virtue of this email exchange, we were able to do it in a week or two. And, absent Health Law Project or an assister like yourselves, having an email exchange like this, the county is going back and forth requesting information via snail mail letters, and there likely is going to be less back and forth just because of the logistical hurdles that go along with that. So this was an example. Let me pause before we move away from applications to appeals. Any questions on anything I've covered thus far or comments? And again, if you want to unmute yourself, it is *6 to chime in. Okay. So the next section of this morning's training goes to appeals, and we'll spend a bit more time on this. So we're going to cover, to start, the mechanics. But I guess a prefatory note here. It's tempting, and sometimes our clients view requesting a fair hearing as intimidating. It's, it's setting in place this legal proceeding. I don't know if I want to go before a judge. I'm not sure I can do it. And for sure, the clients have due process rights. This does begin a formal legal proceeding. But I want to encourage you to think of it as just pausing the situation, sort of less formally. An appeal allows you to require the CAO to review its action for correctness. And again, they know they make mistakes sometimes. But not only do they have to review the action, it also gives you an opportunity to produce additional information, you and the client, right? So it's a way to pause the situation, submit any information that may be missing, even if the client's already submitted it before, to resubmit information, and to have the county act on that without having to file a new application and wait another 2 weeks or 3 weeks or 4 weeks, right? So sometimes, and I know I've worked with some of you, you've developed contacts in your local office and you have a contact who's willing to act on additional information without the appeal being filed, right? That's great. If that's the case, certainly continue to do that. The benefit to filing the appeal is it for local CAOs or contacts who aren't willing to do that, and I can't tell you how many times our clients are told, file a new application and wait, right? That happens a bazillion times a day, right? Filing the appeal gives them a legal protection where the county has to review its action and it has to deal with new additional information, right? So the second point here, going to information that's submitted now, even if the client didn't get it in within the initial time frame, it doesn't matter if that information is late. So we have a rule of evidence stemming from an old court case way before my time called the Juris Rule, and this is in the Medicaid regulations. If the information submitted is relevant to showing that the client is eligible now, the county can use it. It doesn't matter that the caseworker's action last week or last month was right at the time, given the information they have. If the client's able to produce information that shows substantive eligibility, the county has to use it. Okay? They don't have to go to a hearing to defend the correctness of their action last week or last month. And that's a big deal because, again, it goes back to not needing to file a new application. Right? It doesn't go to whether the county's action was correct or not at the time. It's using the income information you have now, or using the information that you have now that that 19-year-old has moved out of the house and is going to be claiming himself as a dependent, mom and dad are now eligible for Medicaid, even if county didn't know that last week. All right, so I do want to pause. We have a question. So we have a question about the importance of having the client sign a disclosure so the county can work with you. Sure, yeah, that's a good point. And can you be listed as a representative on the application? I haven't looked. As we get into appeals, we're going to take a look at the appeal template form, the fair hearing request form that's included in denials. And you can see there's a representative section, and absolutely you want to have the client sign that and list you so that you have authority to act on their behalf. If they haven't included you in the application or on Compass, you can have a basic representative form, template form in your office that they sign that you can give to the county. And actually, if somebody on the call knows offhand, you can certainly feel free to chime in and let us know. Again, *6. If there's a section in the Compass application, for instance, that allows you allows the client to give you permission. So I know the comment here from Diana is that even as a community health partner, some caseworkers won't discuss the case with you unless they have a specific disclosure. Thanks for that question, or that point of clarification. All right. Speaking of appeal forms, so let's spend a couple of minutes talking about how to file an appeal. This is page 1 of 2, so hopefully this fair hearing form is familiar to you. It will come along with any eligibility determination, favorable or unfavorable, and it's a way for the client to file the appeal and say, I disagree with the county action. Now this is a blank form, which is in your materials along with the PowerPoint slides. Then you can use this, but it's better, wherever possible, to use the form that came along with the actual county action, the adverse action. And that's because it's going to be pre-populated. It's going to have the client's name, case number, address already in there. And it's also going to have identifying information, so there's no question what action it's tied to. So when the county or when the client completes it and submits it back, there's no ambiguity as to what they're appealing. The action is on the notice itself. But if you need to use the template form, you can, and you want to, of course, have them fill out all the obvious information, name, phone number, address, etc. Question 4 here, choose the way you want your hearing. This goes back to sort of the more subtle forms of leverage that you can exert in this process. Right? So typically for our clients, the most convenient thing would be to have a hearing by telephone. That's most convenient for caseworkers as well. So this goes back to putting subtle incentives in place for the CAO and the caseworkers to work with you and to work with the client to resolve these as quickly as possible. So for that reason, to put that little bit of extra leverage in the situation, I advise clients to click the 4th box and check the 4th box, face-to-face with everyone before the administrative law judge, everyone at the hearing room. And in part, that's because the vast majority of appeals we file don't actually go to a hearing. The vast majority of appeals we work on can be resolved, certainly eligibility appeals, can be resolved far before a hearing is scheduled, right? So the face-to-face, again, client's not going to actually have to go and be in person before a judge typically because they're going to be able to submit whatever information and we're going to persuade the county the correctness of our position well before 3 months out before that appeal is scheduled. Before we go to the second page here, any questions on completing this first part of the appeal template? Okay. Second page, and this is a little more involved. So tell us why you disagree. And one thing I should have put here that you don't see, if you're using the template, you want to be specific in terms of what the client is appealing. I'm appealing the decision to deny medical assistance dated 12/15, right? Especially if they're not using the form that came with the notice. But beyond that, your client doesn't have to elaborate on why. I mean, they certainly can, and certainly if you are not helping them, if you're not submitting additional information, then you want them to address whatever substantive issues there. But they can also do that in an attached letter, or if you're filing this by email, I mean, you or they can do it by, well, typically I would not actually have the client appeal by email. I'd have them do it with a letter, sort of mailing it in or dropping it off, and we'll get into the mechanics of how to file the appeal. But for those cases where you're helping, you certainly want to elaborate on why the action was in error. You want to do that not on these 3 lines in the template form, but you want to do it in an email or a cover letter where you identified the mistake and then provide the missing information or cite the handbook to point out the error that they made. Signature and date are both required. That's 8 and 9. And then if you're working with the client to file the appeal, if you're helping them in it, you certainly need your information there at 10, 11, 12. Now, you can do it, again, like we talked about, by having a separate sort of standalone authorization form, but just as easy to have them include you in the appeal itself, and then there's no question the client's given you authority to act on their behalf. Any questions about this part of the appeal? All right, moving on then. Mechanics. What's the best way to file the appeal? There's a few different ways to file. Hand delivering it and getting a receipt, or filing it by certified mail and getting a receipt are the best methods. So that proves the client has filed the appeal on a particular date. Certainly, if this is an appeal of an already authorized benefit, so for clients who have already had Medicaid and the CAO is stopping it, you don't want to take any chances. You want them to appeal within the APA pending time frame, and you want them to be able to prove they appealed within that. And that means that would allow their benefit to continue pending the appeal. But for most of your cases, I suspect they're going to be denials of a new application, so the client's not already getting the benefit. A little less important that you were able to prove they appeal within 13 days. You can also file by email or fax. And email is typically the easiest way to submit additional information. If you do the latter two, email or fax, certainly confirm the appeal was received. So follow up with a phone call to the ombudsman or the other contact that you sent the appeal to. And that gives you another chance to say, what else do we need to resolve this? What else do you need to resolve this case? Right? We don't want to take this to a hearing. We think there was a mistake in so far as the county did X, Y, Z. What else might you need to fix this? Time frames. So you have 30 days from the adverse action to file the appeal. That's the statute of limitations, right? And that runs from the date of the action notice. So even if the client doesn't get the notice until 5 days after the date on it, the 30-day time frame is still running from the date of that notice. Now, if it's egregious, if they got it 2 weeks after the fact, try and save the envelope. Hopefully there's a postmark there that can help you. But generally that doesn't happen. I mean, typically there's some lag between the date of the notice and when the client gets it. But typically you're going to have to work with the date of the mail notice. They have 30 days to file. But if they file within 13 days, that's the benefit continuing deadline. So this is hugely important wherever you have clients who already have a benefit active. So to prevent that benefit from stopping, you want them to file within 13 days, and they need to be able to prove they filed the appeal within 13 days. So that goes back to mailing it certified, getting that receipt, or taking it in to the county in person and getting a receipt for it. So those are the first two time frames. Once they've filed an appeal, the state has 90 days to hold a hearing and to issue a decision on that hearing, or for a judge to issue an order in response to the client's hearing. So it's not the fastest time frame, right? And that 90 days that they have runs from the date of the appeal. Practically, for clients who file for fair hearings by telephone, the state files or schedules those quicker. It takes them more time to file an in-person or to schedule an in-person hearing versus a phone hearing. But despite that 90-day sort of time frame to resolve an appeal, and typically it can take 2 or upwards of 3 months before the client has a hearing scheduled, you can start to resolve. You can attempt to resolve that matter immediately. You don't have to wait any time. And typically one of the main strategies you'll see, we're going to talk about in a minute, is giving the county assistance office whatever they need to fix the problem alongside the appeal, right? Because you want them, again, they have an incentive, they have no interest in going to a hearing or even filing the hearing. If they can resolve that issue immediately, they don't even have to file the fair hearing paperwork with the Bureau of Hearings and Appeals. One other piece, and I'm not going to spend a lot of time on this, once an appeal is filed, your clients are sent out a notice of a pre-hearing conference. So that's sort of a more formal mechanism of resolving an appeal, so they can go into the CAO or they can set up a time to talk to the caseworker and supervisor. You don't have to wait for that. So even though that process exists, again, you can fast forward to talking to the caseworker, having your less formal pre-hearing conference as soon as you file the appeal. So moving a little from mechanics to strategy here. Whenever possible, resubmit whatever information is at issue alongside the appeal. Sometimes I have clients who, let's say they recently were awarded Social Security disability, and because of the jump in their income, they no longer qualify for that old Healthy Horizons category they had been getting. And so the county action to stop their benefit is correct insofar as they're over income now for Healthy Horizons. When I work with that client, ideally, we're talking through MAUD, and the client is setting up an informal work arrangement with somebody, and they're already doing that little bit of work and being paid for it, and getting a letter from that person they're working with, and then we submit that letter proving that they're working right along with the appeal. And in that appeal, we're going to say we disagree. Please review and please resolve this appeal by authorizing MAUD. So we're combining, right? 2 birds with 1 stone there. We're telling the county we disagree with the action to stop the benefits, and this is why, because the client is now working and now qualifies for MAUD. If you're dealing with a more obscure, or maybe if it's not even obscure, if it's just an error of policy on the part of the caseworker, cite to the relevant handbook section, right? Let them know that you're looking at the same rules they are, and this is how you think it should apply in this case. If it is something that's much less common, you might print out the relevant section, or at least print out, say, the ops memo or the policy clarification, and you can include that with the appeal as well. And the point, why you want to put so much emphasis on giving them whatever they need at the front end, again, they would prefer to resolve these immediately as well. And obviously, it's in the best interest of your client for these appeals to be resolved right away. Okay, the next point. Occasionally you will have a caseworker or supervisor who is not responsive or who's unreasonable, doesn't seem to interpret it the way you do. If you're on firm legal footing, right, so you know that the way you're looking at this is right, go up the chain of command, right? You don't want to wait 90 days for a hearing. That's unnecessary. So you would certainly also go up the chain of command where you know your client has a pressing medical need. Now, the pressing medical need, though, alone is not enough, right? You need to be right on the merits because it doesn't matter how sympathetic the case is. If they don't qualify for Medicaid, the supervisor or the ombud or the assistant district administrator is not going to be able to turn on the benefit. If you need help in identifying how to go up the chain of command, like who is the district administrator to take this to, be in touch with me. We can help pull that from department directories. Another strategy here, even where it's not technically relevant. So let's say you have a case where it's an appeal issue, it's not expediting the application, But if you have something that makes your client sympathetic, right? If you know your client needs an spinal injection because of whatever pain condition they have, point that out, right? It only helps cut through, again, the huge volume of cases that CAOs are typically dealing with. And not that long ago, with Medicaid expansion, rather, the CAOs were dealing with 20,000 applications a month, right? Huge volume statewide. And, for a large extent, they become numbers, right? These cases you're just churning through, and it's easier to deny or to not spend much time on cases where they don't appear like they're real people with real problems, the caseworker, right? It's certainly easy for them to get jaded in some instances. And you want to try to combat that by just pointing out, right, this is my client who's this old, and this is the health condition she's struggling with. This is why she needs Medicaid, right? So in your appeal, your attempts to resolve the appeal, throw that information in, right? You might not leave with it, but put it in because it can be powerful in persuading the county to work with you and not let this linger. Before we go through a couple of examples, do we have any questions or comments? Star 6, if we do. It's a quiet group this morning. Hopefully you're not all shopping for those last-minute Christmas presents on Amazon while you listen to the webinar here. All right, keeping on here. Common denials. So one we've seen time and again since the state expanded Medicaid, and before that actually, is verifying no income. And this ties back to the old culture, so the legacy in the county assistance offices. Somebody comes into the office or applies for benefits and they say they have no income. The response is prove it. How are you living? How are you surviving with no income? The easiest way to respond to this is to get a support letter where it's possible. So if your client is staying with a relative or a friend, couch surfing, if they can get a basic letter from that relative or friend, it doesn't have to say much. I'm allowing Kyle Fisher to sleep on my couch, and I have been since Thanksgiving. Here's my name and address. That lends some credibility to the client's report that they have no income. And this shows how they're getting by, right? If the sister is allowing me to eat with her, the same thing, okay? So the basic support letter, and it doesn't matter necessarily who it's from. If that's not possible, second best option is having the client themselves write out in a letter. I've been without work, I lived off my meager savings for a week or two, and now I am just bouncing between friends' houses. My friend did not want to give me a letter because they were worried that whatever, right? That piece of paper helps show to the county assistance office, and the worker that the applicant is cooperating. They're trying to prove that they don't have income. And proving a negative is not easy, right? So you'll see there's a blurb here from the handbook, section 350.11. If the client is cooperating, right, they can't be turned down. So as long as you have, and this goes to showing, that basic piece of paper from the client goes to show that they are trying to help prove their income or lack of income. Now, this is a common one for folks who, college students often, also folks who are just really down on their luck and have no income at all. Another issue we've seen a lot of is the monthly versus annual income. And this one came up with state's adoption of Medicaid expansion. So we have an expansion category. We have this very important income threshold of 138% of poverty. But we have a difference, typically, in how Medicaid is looking at income and how the marketplace is looking at income. So Medicaid is using point in time. So essentially they're saying, what's your income now, this month and last month? Whereas the marketplace is saying, what's your expected income for the calendar year? What's your expected income for the whole year? Sometimes those two things are different as a percentage of poverty. So if somebody has a benefit that is expected to end or decrease, and we see that a lot with school district employees, bus drivers, drivers or migrant laborers. Or, really commonly, we see it with people who have unemployment compensation. So it's certainly possible that their income right now is over that 138% threshold, which would point towards the marketplace and premium tax credits, but their annual income, because they know that income is going to stop, is under the 138 threshold. So in that instance, we need Medicaid to look at annual income. And there are rules. They should look at annual income. The problem? Caseworkers have to do it manually, right? They can't. The system does not figure that out on its own. So just because somebody lists I have workers' comp doesn't mean the caseworker or the eligibility information system is going to automatically take into account when their income stops. So the CAO has to go in, or the worker has to go in and do an override. As will not surprise you, they often don't. They need us. They need enrollment assisters or navigators to point out that typically it's going to be in an appeal, but you can put this in the application as well. Please consider annual income. The workers' comp is ending on X date, or unemployment is scheduled to end 40 weeks from now. Right? So this is when we see a lot. If you're putting in the application or if you're putting it in the appeal, cite to the policy clarification you see here, right? February 2015 policy clarification. For whatever reason, the state has not yet incorporated this into the handbook. So cite to this particular policy clarification. Questions on this one or the earlier issue, verifying no income? No questions, no comments? All right, we're moving quickly this morning. Another common issue we've seen is for folks who are applying for coverage under the expansion or the new adult category, and they're being asked to verify disabilities, or they're being asked to verify their savings or assets. And this is a screenshot from Compass that we talked about in the MAUD and disability-related categories webinar. Folks are asked just very broad questions about having any medical conditions or ongoing special health care needs. So where they do that, there's going to be a logic set up in the system where they are going to ask for employability assessment forms. It's going to ask for proof of assets, the value of vehicles, et cetera. Clients don't have to submit that information, but when they decline, they do want to be explicit. You want to be clear. When you want to use language along the lines of what you see here. I'm applying only for the expansion coverage, which does not require proof of assets or disability. Please process my application without it. You want to put that in the Compass application, and if you get a denial or if you get a request for additional information after the application has been submitted, send back a letter with that information on there, right? You want to ask the caseworker to review only in the expansion category where they don't need that information. All right, so to look at a few sample appeals and emails here, this was a denial of the Breast and Cervical Cancer Prevention and Treatment Program, BCCPT. As the name suggests, it's for women who are suffering from breast or cervical cancer. And this I did in an email. Since it was not a ton of information, we were submitting proof, or we're submitting the appeal. And then we had submitted something showing that her creditable coverage, that she had a work-based insurance that was stopping, was going away. That's relevant only for the BCCPT category. So in general, somebody can have Medicaid on top of the work-based coverage, and Medicaid is secondary. So in this instance, you'll see I emailed, it was in the Ombudsman, I think for Bucks County, but I'm not certain of that on top of my head. And we asked that they resolve it as quickly as possible, right? And you'll see, so we go to a contact here, submitted the appeal by email because it gets there instantaneously. And then I put out some information that goes not to her eligibility, although the creditable coverage piece does, but the fact that she needed breast cancer treatment and medications ASAP, right? That goes to the Ombudsman being sympathetic, being moved to act on this quickly. And as I recall, she did. She helped us resolve this very fast. Here's another sample email appeal. And here the client had already filed the appeal, and she had filed timely, but the county still stopped her benefit. So this is an email to Mr. Freeman, who had been the ombud at South District in Philadelphia. We point out the fact that she had already appealed. We point out the fact that her benefits stopped despite that despite the timely appeal. We point out her record number, and we ask that the county reinstate immediately based on the appeal. Now, moving away from the due process piece, trying to engender some sympathy here, child with disabilities who has no other coverage, and then we move to trying to resolve the appeal as soon as possible. Right? So the issue here was they did not have income documentation from the child's dad. So we attached a couple of pay stubs as well. And as always, you want to play nice, right? You want to be useful to your contacts. So typical ending information here. If anything else is needed, please let us know. And of course, thank them. A couple of examples. Here's a more involved email. So this was an appeal I filed via letter rather than email. Given that it would seem like too much information to put in an email. Given that it's a letter, I was a bit more formal in it. You guys can gauge formality or informality depending on the nature of your appeal, and also depending on the nature of your relationship with that particular contact. So here's a Delaware County appeal we filed end of last year for someone who had applied under the expansion category and was denied because he had not verified assets. So we point out basic factual background, what his income is, his age, that he's in relatively good health, and then we point out that he qualified for the newly eligible adult category, citing the ops memo that was controlling. Under 65, under 138%, he doesn't qualify for Medicare. As you guys hopefully recall, those are the three main prongs, the criteria for the adult category, and then again asking if anything else is needed. I think that's it in terms of examples I wanted to walk through. Health Law Project, we do Medicaid appeals, so we're certainly willing to help do sort of technical assistance if you want some help walking through these. We're also willing to take some of the more complicated ones. So if you have a case that you don't feel like you have a grasp of the underlying policy, or you're not sure how to resolve the underlying factual dispute, feel free to, you can hand some of those cases off to us, or you can just check in for the technical assistance, however you want to do it. If you're referring a client to us directly, please send them to our helpline. You see the 800 number there. If you want to touch base to discuss how to best resolve an issue or do more technical assistance, contact me there. It's K. Fisher. I think most of you have my email. Some citations here, or links rather. We have our own eligibility manual. We have the DHS's medical assistance eligibility manual. There's a link to that. And then in their supplemental handbook is a chapter on appeals and fair hearings. So there's a link to that if you want to look at it. Blank appeal form is going to be in the materials. It's posted on the website. One last pause. Comments or questions before we wrap up? Okay. I hope this was useful to you. I hope you guys feel comfortable in reaching out to your CAOs and developing some contacts. Happy holidays. Merry Christmas to everyone. Tia, is there anything else you want to add before we close this morning? All right. Hearing no additional comments, I think we will break. Thanks again for joining us, everyone. And like I said, feel free to be in touch if you want some help working through appeals or any of these issues.
Hello?